Thank you, Mr. Chairman. Before asking my questions, I would ask unanimous consent to place in the record a statement from the American Immigration Lawyers Association and a statement from the National Immigration Forum for the record.
Without objection, they will be made a part of the record.
Now, I recognize the Chairman's discretion to allow members of Congress who testify not to answer questions, and so I didn't raise an issue on that, but I also don't want people to feel that I'm taking an unfair opportunity to point out that our colleague, Congresswoman Black, was the one, I mean, she has, I just got to say this, because I think she, you know, it's very easy for us in Congress to attack career civil servants. They're not able to defend themselves, and I think sometimes it's important that other members of Congress provide their defense. She talked about a lawyer who works for ICE, Mr. Andrew Lorenzen Strait, who is a career civil servant. He has been a lawyer in the agency since long before President Obama was elected. He was appointed to serve as the liaison for immigration detention policies with interested parties, community groups, the associations of lawyers and bar associations. This is not very different than, you know, what local police agencies do, where you have somebody who can interface with community who are interested in policies. To call him an illegal alien lobbyist, I think, is quite a slur and very unfair. And Congresswoman Black, of course, as all of us do, has the opportunity to provide legislation. She did. She is a relatively new member and apparently did not know that if you just prohibit funding for a title, it complies with the law to eliminate funding for that title, but essentially to maintain functions. So I guess she's doing a redo, but I think to blame the agency for her inept drafting is really, again, rather unfair to the agency and also to the career individuals. And I just felt it was important for some of us, at least. I mean, ICE is not my favorite agency, but fair is fair. I wanted to talk, if I could, a little bit, Mr. Schroeder, about the take care clause as it relates to immigration. You know, I went over and listened to the arguments when the Arizona versus the United States case, and it was a fascinating hearing before the Supreme Court. But in the decision itself, this is what they said, quote, "A principal feature of the removal system is the broad discretion exercised by immigration officials who, as an initial matter, must decide whether it makes sense to pursue removal at all." That's what the court said about what the executive's authority is today and always has been. Deferred action has been part of immigration law for decades. This is nothing new. And so I guess the question for me is, if there's agreement that the department has to make some decisions in terms of resources on what to do, given that the Supreme Court has said there's broad discretion to make decisions about what priority to make, do you think somehow it's a violation if there is order put into those decisions by the heads of the agency for policy? Or is there some reason, does this have to be left to officers without any kind of guidance to make that decision on their own?
Not at all, Congresswoman. I thank you for the question. As a matter of fact, if you think about it, if one of the rationales for granting deferred action are the equitable considerations that relate to the circumstances of the people involved in that, affected by that decision, one of the things that is most inequitable to those people is the uncertainty of their situation, not knowing whether somebody is going to come and take an action against them, being completely at sea as to what their status is. Now, that's the normal situation, but if you were going to take deferred action on the basis of a consideration of the equities of childhood arrivals, one of the things you would want to do is put their mind at ease. It would be part of the equity of the situation to do that.
Can I ask one further question? Because it's something, I've often thought about. If you have this discretion, and you do according to the court, isn't there an equal protection issue here where if you have an officer in, one part of the country saying we're going to exercise discretion for childhood arrivals, but an office in another part of the country saying we're not, doesn't that call out for a policy decision on the part of the agency itself on what to do? Isn't there an equal protection motivation there?
One of the most fundamental principles of our jurisprudence, equitable application of the law, is that like cases be treated alike. And if you think the dominant explanation of your treatment of a group of people is shared by all of them, then you need to treat everybody alike. And a case-by-case approach to the problem, in fact, will not lead to that.
I see my time is up, Mr. Chairman. I yield back.